if people could keep themselves on mute whilst we're just talking, that would be great. So we're not getting any sound interference. Said that a few times in the last 6 months. Great. Okay. Kane, is that it in terms of people in the waiting room? Can we start? Yeah, great. Okay, well, good afternoon, everyone. I'm Chris Boyle, Head of Employment at Natlands. Today's the 5th of October and it's 2 p.m, or just shortly afterwards, and this is a Q&A on the EU settlement, on future-proofing your workforce, EU workers and Brexit. And today I'm joined by Angela Barnes.
Hi.
Hello, Angela.
Hey.
Who's a senior associate in our team, the employment team, and a specialist in business immigration. And I'm just going to be taking your questions today on the EU settlement scheme and the new immigration points-based system and other things associated with that. And this could be the first webinar we've done for a long time that doesn't involve coronavirus or COVID-19, which is probably a good thing.
We may touch on it.
Oh, we may possibly touch on it, but there you go. I think we'll avoid that. If anyone has any questions, which hopefully you will, could you please type question into the chat box, and then Kane, who's a member of our team, will unmute you when we get to your question in the list. If you do have a question that you want to type into the box, obviously feel free to do so. But what we want to try and do is have you ask Angela the question so that you can then enter into some a conversation, I guess, and also so we can see you as well when you ask the question. So there we go. So just to kick things off, Angela, I thought what we could do really is just kind of look at where we are now and look at the current position with Brexit on the one hand and where we are in the situation for EU workers in the UK. What's the current state of play?
Yeah, okay. Hello, everyone, and welcome to this session. So in terms of where we are currently, Chris, we are in the transition period of Brexit. So if we all cast our minds back to January of this year, I appreciate a lot has happened between then, but if we go back to January when the UK entered into the EU withdrawal agreement, in short, it gave the UK, or it hopefully would give the UK some breathing time to enter into the various agreements with the other EU countries. So whether it's trade agreements or its immigration policy, the UK was essentially giving itself 11 months to sort everything out in readiness for when we would leave Europe on the 31st of December. So the current position at the moment, transition period, which started in February and is set to end on the 31st of December 2020. Now, importantly for anyone who has a UK business, if you are employing EU workers at the moment, then free movement for those workers continues as normal up until the 31st of December. So what that means is in terms of document checking, in terms of right to live and work in the UK, nothing changes up until the end of the transition period. Now, there are people who are better placed to advise than I am on what may happen at the end of the transition period. We believe we've missed the deadline for extending it, and whether they try and come up with some other way to extend it to give themselves some more negotiating time is still up in the air. But as things stand, we will leave on the 31st of December, and with that, free movement will end.
And then in terms of employees or EU workers who are here now up to the 31st of December, what should they be looking to do now? This is all around the settled scheme, presumably.
It is, yeah. So as I said, free movement is continuing, but employees, European employees who are here now, or even citizens, but especially, as I say, for UK businesses, they're being encouraged to apply for the EU settlement scheme. So you've probably seen bits around this in the news, especially if you're working in HR. But European citizens who are here now are able to apply for the EU settlement scheme. And that scheme's been open for quite a while now. And what the individual does then is it's really a way of evidencing their right to be in the UK. And they've got up until until June next year, so the end of June 2021, to apply for that scheme. But most importantly, they need to be resident in the country before the 31st of December this year. Now, there's two statuses that they can be given. They'll either be given settled status if they've been continuously resident in the UK for 5 years or more, or if they fall short of that test, then they will be granted pre-settled status. So if they've been continuously resident here for less than 5 years. Now, in terms of continuous residency, there's a strict legal test on that, but in short, you can't have had a 6-month absent, more than 6 months absence in any 12-month period. There are certain exceptions to that if somebody's been particularly unwell, or they've given birth, or they've been seconded overseas, and various exceptions, but the general rule is to get settled status, those EU workers have to have been continuously resident for 5 years. So if they have got that settled status, they can then go on apply for British citizenship. If they've just got pre-settled status, then they could eventually apply for settled status and then again go on and apply for British citizenship. So it's just about evidencing their right to be here. It's an application form that you can do on your phone, on your laptop. It takes about 30 minutes. So it's 3.5 million EU citizens in the UK have applied for this. There's still more to do it, but it is quite a straightforward process. And that's how, as I say, as long as they do their application before the 30th of June next year, that's how they will be eligible under the scheme.
Okay, thanks. And I think we've got a couple of questions now from Peter Henry. So Peter, Kane, do you want to unmic Peter's microphone so you can ask the questions? So you've put them in the chat box, but happy to ask them, yeah.
Right, unmuted. I've actually got 3. Let me just type this last one in. Yeah, is there a downside to applying for EU settled status to anyone who's got a UK address but who's from an EU country?
Yeah, I mean, I can't think there is a downside. What I've found with clients, Peter, is that some EU citizens in the UK simply don't want to apply for the scheme because they see that, they believe that they shouldn't have to. So, we look at other, we look at the Windrush scandal, for example. They don't feel that they have to demonstrate their right to be here in that way. So that can present problems between employee and employer. But I can't think of a particular downside. It doesn't mean that in any way they would be ineligible under any other scheme.
Do you know what happens, Angela? I share your view. It's just I've got one very cautious member of staff. Mm-hmm. Just to give you an idea, I'm from a company called Origin Spinal Injury Care, and we employ about 130 care workers, live-in care workers, and probably 80% of them are from EU countries or non-EU countries, mm-hmm. The rest are Brits. And we've got just about every country in the EU represented. My co-director is Danish, although she's not directly affected by this, but the care workers most definitely are. And we've got a selection, some working who've got addresses here, who are applying for the settled status. Many others, having spoken to the settlement office, many others are working as what's called frontier workers, in that they live in another country but work here, essentially commuting here.
Yes.
So one question I have was, if somebody is working as a frontier worker now, as in before Jan 1, can they continue working as a frontier worker next year?
If they've applied for the EU settlement scheme?
No, if they haven't got an address here, they can't apply for EU settled status. I've tried that.
Yep.
And the EU settlement office advised that all people who don't have an address in the UK should work as frontier workers. Now, if somebody's working as a frontier worker now, can they continue next year?
So that's a good question. And I think, to be honest, Peter, that's one that's still up in the air, because when I attended the, I don't want to take up too much of everyone else's time, but when I attended the Immigration Practice Lawyers Association seminar last month, that was one of the questions that was put to them, because there is this issue whereby for frontier workers, as Peter said, so they're the people who are working in the UK but not necessarily living in the UK, and we have these workers all across Europe. It's which is the best route for them. So there was some discussion about whether actually going for the EU settlement scheme would be better if they are eligible. So it may be that even though they're travelling around a lot, they are still eligible. But there is also frontier workers visa. I don't know if you've looked into that as an option, because that, I think that's recently launched, isn't it?
Well, they are working as frontier already.
Under that
it may be, Angela, better for you and I to talk after this, but also another question was, can somebody who's not even heard of us next year, for example, June next year, can they apply to work as a frontier worker from scratch? But rather than taking everybody else's time and monopolising the session, perhaps you and I can pick this up another time.
Yeah, I mean, I'm more than happy to answer it, Peter. I think the short answer is, for the benefit of everybody, it's the subject of much debate, and it's a very grey area. Even into next year, we're not sure on the position for frontier workers. But yes, Peter, it's definitely something. Let's catch up separately and go into more detail on it. And equally, if it is of relevance to other people who have frontier workers, again, happy to pick up separately with you as well.
Thank you very much.
Okay.
Thanks, Peter. We don't like grey areas, do we? But yeah. Okay, before we move on to one of my questions, I think Gillian Crothers, hi Gillian, has got a question. Kane, could you unmute? Oh, you're unmuted. There you go.
Yeah, my question is about, we are a seasonal business. We do educational printing, so mainly textbooks for schools. And in the summer period, we have Polish staff that only work for us during the summer. So what they do is they come over, and at the moment they can do that quite freely, spend 3 or 4 months and work here and then go home. So they live in Poland. What will happen with them? Will they be able to do that? I've looked at some of the skills test, etc., and it's not a skilled job. So we're just wondering whether or not we'll still be able to do that.
Yeah. And that's a great question, Gillian. Again, maybe not the answer that we're hoping for, but they will, if they are coming to the UK after 31st of December, so as you've said, they're seasonal workers, so the new system, the new immigration system would apply to them. And as you quite rightly said, and we'll look at this in more detail, I'm sure, as this session develops, but they need to be what's regarded as a skilled worker, and they need to be receiving a certain level of pay, have a certain level of English language. And that doesn't fit well with this category of worker. And the reason the scheme was introduced was to reduce overall net migration. And this is the area that it is hitting hardest. There isn't a solution to your potential problem that is obvious. In other sectors, for example, in agriculture, they are piloting different visa options where they can still get those seasonal staff in who do work for 3 or 4 months of the year, and then they go back to their home country. There isn't such an equivalent outside of agriculture yet. So at the moment, it would either be that these individuals have already perhaps been here and applied for the settlement scheme, and that means that they can come back again, or it would be that we need to get them to a level of skill or level of pay that they could come in under the new system. But other than that, it gets, as I say, there isn't just a simple, way of doing that. I guess the other way is we could look at a tier 5 potentially, which is a different category under the existing system, but it will carry on into the new system, where it's pretty much a government exchange scheme where, for example, at the moment, an Australian individual, young person, can come and work in the UK and pick some asparagus and go back again, and they can do that for up to 2 years. And we have a reciprocal arrangement with Australia where we can send someone over there to shear sheep or whatever it might be. And now it may be that when we get this new system in place, perhaps there may be similar reciprocal arrangements with EU countries. So with Italy, for example, or Spain, there may be something where we can do a temporary exchange of people, if you like. But at the moment, as things stand, there's nothing in place that is similar to how we're working with other countries outside of Europe. Okay.
Thanks, Gillian. Does that answer? Yeah, answers the question. It's great.
Yeah.
We'll come on to some more detail in terms of the scheme, Angela, but I just wanted to pick up on one point there around unskilled workers and this debate around unskilled workers. What is the government actually expecting employers to do if they can't bring across unskilled, to use the term?
It's a difficult term, but it's the one that the government use. What they're expecting to do is the whole point of this, as I've said, is to reduce overall net migration, and to do that, they want the UK to become less reliant on foreign labour, so EU and outside of EU, and become better at coping with the labour force that we've got. Now, whether that means increased automation, so we need fewer people to do certain roles, for example. I mean, the other option that some clients have looked at, and indeed some really big organisations that I've seen in the news, is to diversify the talent pool within the UK. So I saw the Travelodge, for example, they were trying to think a bit more creatively about how to use the UK workforce. And in 2019, they tried to broaden their recruitment searches, and they were advertising specifically for school hours contracts, which they'd not done previously. So that was a gap in their recruitment, but also, other ways, more flexible working, which obviously we're seeing anyway. And also things like, does a certain job need a degree level, or can we think a bit more openly about using people in the UK that we wouldn't otherwise have thought to use? And that's what the government, in every message that they're sending to us, that's what they're really pushing. It's not so much about how to get European and non-European workers into the country. It's more about facilitating what we've got here and how we can use that more effectively going forwards.
Good. If anyone does have a question, please put question in the chat box, or the question you've got in the chat box, and we'll take the question. But just moving on now, I guess, to some of the detail around this new system from January 2021. What actually is the new immigration system, and how does it apply?
Yeah, and probably, Chris, it's worth, and sorry if this is going over old ground for some people, just for me to summarise what the position is now.
Yeah.
Because only then can you really understand what the changes are going forward. So obviously when this new system was introduced, it was meant to be this revolutionary new points-based system. There was talk of it being like an Australian points-based system. In fact, it's more of a tweak of our existing system that we already have here. And the system that we already have is a 5-tier points-based system. And in order for a non-EU worker to come into the country, because obviously at the moment it only applies to non-EU workers, for them to come here, they have to score sufficient points in one of the 5 categories. So tier 1, for example, is for really highly skilled individuals. So entrepreneurs, investors, those wanting to start up a business, they're the sorts of people. So, they might have £2 million to invest, or they might have £50,000, but a really good business idea. So it's obviously only for a certain category of individual. It does work, and we've brought plenty of people into the country on the tier 1, but it's for a very small number of individuals coming into the UK. Tier 2 is your skilled worker. So this is the one that Gillian touched on before as a potential option for bringing people in. But there are salary requirements, skill level requirements, and I'll talk about the changes to that in a minute. Tier 3 of the existing system was for the lower skilled workers. So the tier is there for us to use, but it's never been brought into force, and it's certainly not the case that they're talking about bringing that in now. So we can't use tier 3, and it never has been used. Tier 4 is for students, so if somebody wants to come and study here, so that's a well-used tier, but not one that I'm going to dwell on today. And then tier 5, as I briefly mentioned to Gillian earlier, is for things like youth mobility. So it's normally for shorter term visas, so youth mobility is for 2 years, and it's for example, for people to come and experience life in the UK for a couple of years, but it doesn't necessarily lead to a settled status here in the UK. So they're your 5 tiers under the existing system. Now, the biggest changes, so that we're now talking about from the 1st of January onwards, are to tier 2. So rather than it being called tier 2, it's getting a new name, as you'd expect with the government. So it's going to be called the skilled worker route. But there are also other changes. And obviously, because this new system is going to apply to EU workers as well as non-EU workers, the government have tried to make it more accessible so that more people can come. So, for example, that the main changes, for an individual to come in on tier 2, the job has to be at a certain skill level, and that's on a qualification framework. It's called an RQF, and it's currently level 6, which is degree level, but they're dropping it to RQF 3, which is A-level equivalent. So that's not that the person has to have that qualification, it's that the job is at that qualification. And if that's as set out in the standard occupational code. So if you were thinking of bringing someone over, you'd look at a list of job codes that are at RQF level 3, and if it's on that list for RQF level 3, then you could potentially look at bringing someone in who is at that skill level. The other most significant change is in relation to salary level. So this currently is really quite prohibited. So you have to be on £30,000 to come into the UK on a tier 2. What they've done is they've dropped that to 25,600, or the going rate for that job, whichever is the higher. So, for example, if it's an engineer that you're looking to bring in from Europe or from outside of Europe after the 1st of January, the going rate for an engineer is probably going to be higher than 25,600. So you'd have to pay them at the higher rate. But the rate for other people might be lower than the 25,600, in which case, as I say, you pay them the higher rate. Now, although we didn't get this Australian points-based system, there is an element of trading points that wasn't previously or isn't previously in the current system. So if, for example, somebody's got a relevant PhD, which again, for the jobs that Gillian and I were talking about earlier, it's going to be unlikely, but for some jobs it might be there. If the individual has a relevant PhD, so relevant to the job that they're going to be doing, that might mean that you don't have to pay them the 25,600 or the going rate. You could pay them a lower amount, down to as little as £20,484, because there is an element of trade-off there. But the absolute minimum that you can pay them, even allowing for some degree of trade-off, is £20,484. So again, if we're looking at lower skilled people who are earning below that threshold, tier 2, or skilled worker as it will be called, is not going to be an option for them. Other changes, again, quite significant really for existing sponsor licence holders. So for anyone who is an existing sponsor licence holder, you'll know that you have to carry out what's called a resident labour market test before you can employ someone under a tier 2 visa, and they're scrapping that completely. So whereas previously there was very prescriptive way in which you had to prove that there wasn't a settled person in the UK who could do that job, so you had to advertise the job for 28 days, you had to screenshot the first day, screenshot the last day, prove that nobody could do it in this country, more or less. That's slightly flippant terms, but that's more or less the position. That's going to be gone from the 1st of January. All you have to do is show that there is a genuine need for that vacancy, which is a much lower test, much lower threshold than the previous resident labour market test. So for anyone who is a sponsor, there's been people jumping up and down when I've had client calls and shared that news, because it was quite an onerous exercise. And just some other changes with the new system. So as is the case currently, there's a cap on the number of certificates that you can give to employees who are coming to work here on a tier 2, and that cap is being scrapped. So it's a national cap of 20,700, and although it was never really reached the maximum, it was more the hassle of having to apply every month and checking the monthly allocation to make sure that it wasn't above the relevant threshold. So the cap will be gone, because obviously there are going to be far more European workers coming in, as well as non-EU workers coming into the country after the 1st of January on this system. So they didn't want to have the limit of the cap. Other minor changes, things like switching between categories, is going to be a lot easier. So the new system is definitely less prohibitive, but obviously for the sheer fact that any EU worker is going to have to use this system to come into the country to work after the 1st of January, that's going to be far more onerous than free movement, when they could just, you need to, build it into your recruitment exercises that you can't just rely on an EU worker to be there quite instantly. You're going to have to go through the process of getting a license and then issuing a certificate, so that then they can make their application and come into the country on the new system. I hope I haven't lost you there. It's quite
no, it's a long answer. And then in terms of the sponsor license now, which employers are going to have, and of course I guess deal with clients who are kind of thinking of this and thinking whether they should apply for a sponsor license. What sort of things do you think organisations should be thinking about, really, before they engage in that fairly lengthy process, potentially?
Yeah, I mean, the main thing, and the thing that I've been advising clients, is to look at your pool of people, and how reliant are you on your EU workers on particular, especially in particular parts of the business. So you all almost imagine that if overnight 10 EU workers were to disappear from one particular area of your business, what would the impact of that be? And if the impact is that you couldn't produce what you need to produce, or you couldn't meet service times that you need to meet, then you need to be looking at a sponsor license, because that could very well be the picture that you're looking at in January, February next year, when free movement ends and you haven't got that labour supply. So it's a very careful audit of your existing staff to find out how dependent you are on EU workers. And now to balance it, because as Chris has said, a sponsor license process, it isn't an easy one. And I have plenty of clients who've come to me after they've applied and said, it's gone wrong, it's been rejected. So it isn't an easy process. The things to think about are, it's quite expensive to get a sponsor license. So if you're a large employer, which is if you've got more than 50 employers and a turnover of more than 102 million, you're talking £1,500 just for your application fee to get the license itself. You've then got ongoing costs. So every time you issue a certificate to an EU or a non-EU worker, there's another £200. And then there's charges that will be levied against you for using those certificates as well. So you may have heard of a immigration skills surcharge. So it does mount up. I saw an estimate the other day, actually, where someone had said it's costing their business approximately £8,000 to £9,000 per migrant worker to bring them in under the sponsor license. Obviously, once you've got the license, you can use it as many times as you want. So there is a cost element, but having said that, obviously, if that's the way that you can retain EU workers and widen your pool, because if you have access to EU workers after the 1st of January and others don't, then you are going to be one step ahead if you do need that recruitment going forward. It's money well spent, but think carefully about it. It's not something to undertake lightly, and there are various obligations that come with a sponsor license as well. So it's not something that should be done on a whim.
I was just going to say, with others, we've experienced this before, but with individuals who are the kind of key stakeholders in organisations for sponsor license, what sort of obligations are on those individuals?
Yeah, so when you get given your hopefully get given your sponsor license, you get set up on what's called a sponsor management system, where that's like an online resource for managing your migrant workers, and you need under that that piece of software to comply with various obligations, but you also need certain people in place to deal with to manage the license. So at the very top end, you probably want somebody around director level, somebody who is on the hook, if you like, if anything goes wrong, if you sponsoring a worker and they go missing, then they're called an authorising officer. So someone with ultimate responsibility for your sponsor licence, because at the end of the day, you are trying to demonstrate to the border agency that you've got people in place that can be accountable, and you know, in a kind of quasi-parental role for these workers whilst they're in the country. And then you need someone who's a key contact, so someone who's going to report everything to the border agency. So, for example, if a sponsored worker changes job, or their salary changes, or they move to a different factory, all of this has to be reported under the sponsor management system to the border agency. And your key contact is the person who has that direct dialogue with the border agency if they've got any queries. But you'd also have people set up on the system who can make minor changes as well. They're called your level 1 and your level 2 user. So it's and one person can do all 4 jobs. It's not an easy task to undertake, and I'd normally recommend that you share the love in that regard. But it's quite heavy in terms of workload, especially at first, because you have got these ongoing obligations to the border agency.
Yeah, that's great. And then you were talking before about the new points-based system, obviously, which we're coming into, and I've seen this number of 70 points banded around. Is that now, or is that as from January?
Well, it's the same actually. So going forward, so it's best and easiest if we can break it down. So there's 50 mandatory points, and then there's 20 discretionary that you can trade. So your mandatory points are that you get 20 if you've got a job offer from the employer. So that's basically your skill level that I talked about, your RQF 6 dropping down to 3. You've then got 20 points for getting the right level of pay. But if you're paid more, you can get 40 points. But if not, this is where the discretionary extra 20 points comes in, and because you can trade if the salary is going to be quite low, but if they've got a PhD, or if they're a new entrant into a category, so they're straight out of university, for example, there is that little bit of flexibility with the 20 points, potentially 40 for the salary. And then the other one to bear in mind is the 10 mandatory points for English language, because whereas obviously Polish workers, Spanish workers can at the moment come into the country and work, and they don't have to have an English language requirement, but going forward after the 1st of January, they're going to have to either be from an English speaking country, or they're going to have to pass an English test, before they enter, to prove that they meet that requirement, just as non-EU workers do currently. So that's your 70 points, Chris. It's 50 mandatory, but then it has to come to 70, but depending on where you want to pull from in respect of salary or other qualifications.
Okay, good, great. And then just moving on, if anyone does have any questions, by the way, you can put them in the chat box. I've got plenty to go, but feel free. Just moving on now then, kind of looking ahead. Obviously I think we triggered Article 15, 29th of March 2017. That was obviously after the referendum. We're moving now to go through this transition period to the end of the year. I mean, what has been the impact thus far of Brexit on recruitment generally?
Yeah. And you mentioned then Article 15 in March 2017, and that, to be honest, was a trigger point in terms of recruitment, because even from that point onwards, we saw a sudden decline in individuals coming and seeking work from Europe into the UK. So the hit was instant. It was more prevalent in certain sectors. So agriculture was hit hard, construction was hit hard, retail and hospitality as well. So for the past, we're into the 3rd, nearly 4th year of that now, aren't we? And it hasn't recovered. And even, as I say, I attended the ILPA conference a few weeks ago now, and there was George Shirley attending, who is a senior individual at the border agency. And we were expecting a surge in sponsor license applications, and the border agency are ready and they're resourced, and to say that of a government body is quite something really, but they were expecting everyone to be ready for this. And I think with one thing or another, whether it's because generally UK workers aren't coming as much at the moment, or obviously the effects of corona as well, it seems that both individuals and companies aren't quite they're not quite ready for this or dealing with it yet, and so they are expecting that between now and Christmas there will be a surge, because some businesses need EU workers from the 1st of January onwards. It's crucial to the survival of their business, and they don't yet have a sponsor license. So the impact has been unprecedented really. I mean, I suppose just on the flip side, some EU workers have been reluctant to leave because they're worried about the impact that might have on their applications for EU settlement schemes. So if they're trying to get continuous residency for the 5 years so that they can get settled status, they have been inclined to stay put. But that number is I think vastly exceeded by those people who just haven't come like they normally would.
Yeah, and I guess going forwards, the irony will be that perhaps people coming into the country may be reduced in any event because of coronavirus. There, I've actually mentioned it, but will potentially be reduced. So that'll be interesting to see. We've got a question now, which I'll just read out from Jodie. Thanks, Jodie. Once an employee has settled status and we have received right to work, share code and saved document on employee file, no further checks are required for this employment related to right to work. I'm not sure that I understand that question, Jodie. Anyway, perhaps we'll come back to that in a minute. Next question is kind of from Gillian. What about existing employees? When should we ask, and what if they don't get settlement?
Yeah, good question. Another good one. The border agency have been quite clear with this, that employers can be asking for evidence of settled status. So, you can go onto the individual's application and actually log in with their details, with their permission, of course, and you can see that they have EU settled status. But the government have advised great caution when it comes to this, definitely in respect of discrimination, and they've even cited that as being a way in which employers need to be cautious. We can't be pressing employees to apply for the EU settlement scheme. We can't be demanding paperwork to prove their right to work. The government have said that they don't need to provide that evidence even up until June next year. So it's, as I said, be a bit careful with that. We can encourage, we can support. The government have posters and leaflets that you can leave around to help people who might want to apply for the EU settlement scheme. But at this stage, it's not a requirement to prove their right to work. That will be a bridge that we will need to cross sometime before the 30th of June next year. I hope that answers the question. I maybe got a little bit lost there.
I think it does. And then just if an employee receives settled status, the right to work, etc., everything's resolved that way. Is that it, or are there further checks then required for that employee, right to work checks and that sort of thing?
Yeah, so if you've, I mean, I don't know how you've got that evidence, and I presume it's for an existing employee. So you probably, if they're an existing employee and then they've applied for settlement, then you probably have done all the checks anyway. And if they come waving a piece of printed out email about the settlement scheme, then by all means take it and put it on their file, but they don't need to give you that. But yeah, if they've successfully applied under the settlement scheme, then that's their proof of their right to work. And come January, it's all going to go online anyway, so document checks are going to be fully online from the 1st of January. So I think by the sounds of things, I might need to know a little bit more about it, but it sounds like you've done enough for now. It's not that you would then need to go and do retrospective checks. I'd only caveat that is if you've done a COVID right to work check, which is where, I don't know if anyone's got any questions about this, but at the moment you only have to do the checks in a certain way, a socially distanced way, and you might then need to do the checks again once we're in a COVID clear environment. But that's a slightly different scenario.
Okay, good. And then if we look at some practicalities, Danja, then in terms of what should employers actually be doing now, so preparing for the new the new system going forwards. What do you think, or what do you say that employers should practically be doing?
Yeah. So in terms of getting ready for the new system and for free movement to end, as I said earlier, auditing is key. And I know a lot of clients have already gone through this process, but look at how many EU workers you've got in, which parts of the business. Have an awareness of which ones have applied for the EU settlement scheme, if you can, in a very supportive way. And just to know that, I guess it's about your future-proofing point that if these EU workers don't apply for the EU settlement scheme, there will come a point in due course where they don't have the right to be here. So it would be good to get some visibility on that, but don't push the point. Another thing that I would be doing now, especially in terms of the settlement scheme aspect, is provide support. So lots of my clients have had drop-in centres where people can come and talk about if they're having problems with their application process. What I've found is if people don't have a national insurance number, it's a lot more difficult. If they do, then it's much easier to prove residency. So they may have problems, and at the moment, it's a real worry for staff. So be as supporting, as encouraging as you can. And I know some clients who've gone so far as to offer out independent legal advice to these individuals, because you can't advise them legally. It's against the law, but you can give them or offer for them free independent legal advice to help them with their settlement process. Or even, some people might not have a phone or a laptop to do this on. Maybe they're warehouse manufacturers and they don't have time in their working day, so you could give them a slot of time to come and use a laptop and to actually do the application process, again in a supportive rather than a forceful way. And the other thing to check, a bit of an outside point, but if you have UK workers who are working across Europe, they're also going to have difficulty, because free movement is also going to end in those jurisdictions. So I have had clients on the phone for the last couple of weeks talking about people who are perhaps working in Italy or Germany, and what's going to happen for them. So again, be that source of support. You might not know the answers, but at least you can talk to them about that and help them get some legal advice if they need it. The other thing that some clients are doing that to future-proof, to minimise the damage caused by potential damage caused by the new system, is to encourage EU workers to come into the country now. Because at the end of the day, it's a lot easier to come in now than it is going to be from the 1st of January. So is it an option? Gillian, for example, I know, we talked about them only being seasonal workers. Is there any way there's a job for some of them now? Maybe not, but for some clients, it is an option where they can bring them in now and they can employ them, right through. And then they can obviously apply for the EU settlement scheme, and then it won't be an issue going forward. And as said earlier as well, Chris, just again, getting ready for the new system, try and think outside of the box in terms of doing what the government sort of intend you to do, which is to try and diversify your talent pool from within the UK and make jobs more appealing to a wider group of people, and then you may be less reliant on EU and non-EU workers going forward. But again, it won't work for every business.
Yeah. Conscious of time, so we've got a couple more questions, but just one thing that did strike me, and it's been on the news recently, which I just thought I'd ask you about, and that's the specific treatment of NHS workers, or that sector. Seems that they have some kind of special exemptions or provisions. Just do you want to explain?
Yeah. So there are exemptions in terms of extending visas specifically for NHS staff. So that might be an option. I don't know if there's NHS clients on the call, but potentially, they're rolling out the red carpet for anyone who's working on the front line, basically. So extending for up to a year. And the other option, which I'm seeing more and more of, is there was a new visa category launched in August, which is called the health and care visa. So this might be applicable for anyone who's got care sector organisations who's on this call. And although it's a new route, it falls within tier 2, so it's not, it's one of those new but old routes, really. But what they've done is they've made it much simpler, much quicker, and much cheaper for certain care-related workers to come into the UK. So, for example, nurses, anyone who's either working for the NHS directly, or maybe is perhaps making medication for another company, a pharmaceutical company or whatever, to then provide medicines or equipment to NHS. They've got to have that NHS link. So that's potentially an option for some, where, as I say, it's cheaper, so the application fees are lower. And they're doing a priority service for that, which means that they turn it around much more quickly. So it's something to think about if if you are struggling to recruit in that sector.
Okay, great. Just conscious of time, we're nearly 10 to 3. Just my final question, really, and that's around document checking, really. So we've had this obviously for a significant period of time in the current system. What changes, if any, are going to be made to the right to work checks going forward? And specifically, I think you touched on it before, but specifically around COVID-19 as well.
Yeah, so I'll cover off the COVID point first, Chris, just because we love talking about it, of course. So at the moment, if you even Google coronavirus right to work checks, you will see that the government have issued specific guidance on how you carry out your right to work checks at the moment. What they've tried to make it do is to make it easier to carry out socially distanced document checking rather than seeing the person. Important points to bear in mind. So firstly, you can have you can do the check by virtual call, so like this on a video call. And what you need to do is to get the applicant to send their documents to you beforehand, so they can scan the originals, email them over to you. And as the document checker, you need to be looking at the screen on the one hand and the person sat in front of you, and on the other looking at the documents that they've sent to you and doing the usual, what you would do if you were to see them in person. And so you don't need originals at the moment, which that's a help, because sometimes that can be more difficult. So you need to do the check-in in that way. But importantly, the actual nature of the check, still make sure you're following the employer's checking service guide, because in terms of, do they look the same as their passport photo, or is there something to be suspicious about here? It's still the same level of obligation, so you do need to be mindful of that. Still follow your list A and your list B for getting the checks right. And what the border agency have said is this guidance is in place until they say it is no longer in place, and after that you will be required to do a retrospective check within 8 weeks of the COVID ending, which I don't know when they're going to deem that to have ended. But there will be at some point a requirement to do a further check. But again, look on the guidance, because it is very clear. It even gives you example wording to use. So to say, I have had a video conference call with Chris and I looked at his documents at the same time and I carried out a COVID compliant test, and then there'll be more wording for when you have to go back and do the retrospective check. So that's the specific COVID right to work checks. Going forward, so after January, we've not got anything specific in terms of how right to work checks will change, other than the news is that they're all going to go online. So I would expect we'll hear more about it. I mean, suffice to say, there's definitely still going to be a requirement to carry out the checks, but they'll hopefully be a lot simpler. Again, when we spoke to George Shirley at the border agency, he suggested that the whole process of right to work checks, obligations, reporting, etc., under a sponsor license, the whole thing is going to have an overhaul, and it's going to be a much more straightforward system. But they've got other priorities at the moment, so I don't expect there'll be huge changes to the other parts of it until well into next year, or even 2022. But yeah, there will be changes, so watch this space. I think, Chris, is the best message.
And then just on a final point, and on a linked point, it wasn't so long ago that we were seeing a number of enforcement measures taken by the government around breach of right to work check documents, and they almost felt there was a move to kind of enforce more. Is that something we're still seeing, or you're still seeing? Or?
Yeah, I mean, we're definitely seeing it, and you know, there are penalties and quite severe penalties. So you need to make sure that even in this pandemic world we're living in, that you're still, you know, on top of things like that. The one thing I would say is the border agency haven't been doing as many visits. That's either, you know, to check for unlawful workers or to check for sponsor license compliance, and that's, you know, for obvious reasons. But they are picking up again. You know, the message from George was that they are picking up again on that, and they will be doing more compliance visits. So what they've done is put them on hold. I think if we were to go back more into lockdown again, I don't think they'd put them on hold again because they have such a backlog. I think they would look for reasons why they might want to visit you. So if they get a tip off, or if they have a concern that's, you know, arisen for some other reason, they will probably, and again, I'm speculating slightly, but I think they will focus on those areas rather than a broad brush random visit to come and check. But, you know, the point being, you should always be prepared for a border agency visit, because, you know, they can just visit out of the blue, and, you know, make sure that, you know, if do your audits, check that your files are up to date, because it could happen.
Okay, well, thank you very much, Angela. It's now 5 to 3. If anyone else has got questions, then now is the time. Otherwise, we'll complete the Q&A. Let's have a look. No. Well, thanks very much, Angela. Thanks everyone for attending as well today. Hopefully that's been of some use. We will send the recording out to everyone so you can watch it back at your leisure, and we'll be putting it on our HR3 sites as well, on the Facebook page for HR3 clients. If anyone does need any of the assistance or support on the new system, immigration generally, then please let us know or speak to Angela, and we'll be happy to help. But for the moment, thank you very much, and we'll see you all soon. Thank you.
Thanks, everyone. Bye.